where or how the dust has settled, and then to approach the common issues that we're all finding in practice and trying to work out whether there are some key themes. So Mona, I'm going to ask, Mona is our wonderful marketing manager. She's assisting me with my slides. So Mona, can we get the slides up, please? And then we can run through my talk. Great, so I'm going to cover 4 main areas. The first one, the Coronavirus Act, has been covered extensively by other people. I understand that, and I'm sure lots of you will have already attended webinars in relation to the Act and the very important widespread changes it's brought in, not only just for NHS bodies, but local authorities and a whole wide range of other bodies, including inquests, coroners, etc. Important point to note from the outset in respect of this is it appears like the first judicial review challenge has been launched, I think at the end of last week, possibly yesterday, challenging the local authorities' failure to implement their Care Act obligations. Of course, we'll talk about the easements in the Act, but there's provision in the Act, of course, for the local authority to derogate with a small d from those responsibilities. So I think the first JR has been launched, so watch this space. Topic 2, I want to talk about contact, because that frequently comes up. Certainly with our 21A DOLS challenges and more generally in respect to people who lack capacity. BP, a well-known, very recent case with Hayden, sets out some views on contact. So I want to pause and just look at how contact in practice is happening. Third topic is something that the Vice President and Hive, the working group working through all of the issues caused by COVID, is concerned about. It's something that I can actually give everyone a bit of first-hand knowledge from, having been involved in a case relatively recently that was conducted entirely by Skype. And it will be interesting just to review the respective opinions of how successful that was. 4 is capacity assessments, getting lots of inquiries from local authorities, but also not in the welfare sphere, but in the financial and property arena, about how to go about capacity assessments in circumstances where it's very unlikely you're going to have face-to-face contact. It's important, as you'll see at the end of my talk, that regrettably, because of this crisis, there's an increased need for or desire for people to start making wills, to start entering and registering LPAs because of the concern about their own welfare. So it's important, even in a private financial capacity, to get capacity correct. But Mona, can we turn into the next slide, please? So Coronavirus Act, Royal Assent, obviously on the 26th of March 2020. I think it was passed on the 19th of March, an incredibly short period for such a dramatic piece of legislation. As I've already said, very widespread. It affects pretty much every area of life. It had been preceded very shortly by the Ethical Framework for Adult Social Care discussion paper, and that really anticipated the wide-scale changes that the Coronavirus Act was going to introduce by setting out what is a current theme throughout almost all of this talk, is kind of do what you can, and do what you can to redirect the resources in an appropriate and necessary way. And that's quite a difficult, I think it's quite a difficult concept for public lawyers to grapple with. And certainly in relation to those without capacity, it's increasingly becoming difficult. The Coronavirus Act immediately suspends one of its most profound features, immediately suspends the duty on the NHS to carry out their assessments under Section 14. It doesn't, of course, stop the CCGs from assessing continuing healthcare needs, but it removes the duty to do so. So this is profound in a number of ways, but most obviously, it removes the the opportunity for people to have their needs assessed without financial consideration, and therefore have the wide spectrum of options available to them on the table. So it's a very important suspension of that duty. I don't really want to focus on the impact of this act on NHS CCG resources. Judging by some of our participants today, they are local authority based. So let's turn now to how it affects the Care Act obligations on local authorities. Everyone will know, I'm sure by now, that the Act is a little curious in that it sets out a method of easement for the main duties contained in the statute. Now, easement is used apparently at much consternation to property lawyers, but anyway, it allows a local authority to claim an easement, to derogate from any duty and claim protection under the Act in circumstances where it's no longer reasonably practicable for it to comply with its Care Act duties. And any change and any derogation from that should be proportionate. But it's important to note that some rather cursory reading of the Act suggested to early commentators that this rewrote all of the local authorities' obligations. Of course, there are still important persisting obligations that the Act doesn't change, and we're going to hear from Tom Jones in a moment about DOLS. Of course, this Act does not remove the obligations under DOLS. There is still a fundamental duty, non-negotiable, non-derogable duty to protect and safeguard those in local authorities' remit, and of course continuing Equality Act duties. So we've got to remember it keeps some duties intact, and then it attaches a sort of secondary option to claim an easement, the main ones being duty to assess needs under the Care Act, Section 9, duty to assess the needs of a carer, written records of any assessments, and those sorts of things, which are all contained in Schedule 12 to the Act. I mean, again, so important is the fact that Section 18 and Section 19 are completely rewritten. I've got the wrong reference in that slide there to Care Act 2020, I've just noticed, it's obviously 2014. Section 18 is rewritten so as to impose upon a local authority to meet an adult's needs for care and support only if the adult's resident, that's no change, but 2, the authority considers that it is necessary to meet those needs for the purpose of avoiding a breach of the adult's rights under the European Convention of Human Rights. So there is a direct reference to a sort of base standard of protecting that adult's rights under the ECHR. That's mirrored again in Section 19 in respect of care and support and needs for financial assistance. So what we see, interestingly, is this Act introducing the notion that local authorities have to go back to sort of basic principles in the international agreements and obligations and conventions of the ECHR. Now, why does that matter? Well, apart from it simply being interesting to see that feature so prominently in a piece of domestic legislation, one wonders, and commentators have wondered, whether this will open up a greater exposure of public bodies to reference to the positive duties contained in those provisions. Now, of course, the positive provisions mainly, which we see discussed in BP, which I'll get to in a minute, are right to life and the positive duty to protect life. It's interesting when one applies the new test to, just using BP is not the best example, but for example, someone who is in a position of care or residence where they are exposed to the virus, and there is a risk that their continuing residence there will expose them to that risk. Is that a breach of a positive duty to remove them from that environment? Unfortunately, that wasn't an argument run in BP, but one can well see, and commentators are suggesting, that the introduction of this direct reference to the ECHR, the international norms, will not only see a greater increase in decisions being judicially reviewed on this basis, but also we may see cases being framed in a more international way, including reference to the rights of persons with disabilities, which hitherto judges are reluctant to hear argument on in the domestic court. So without going into too much detail in this short space of time, I think it will be an interesting next year to see how this all plays out and whether we will start seeing much more purist public law ECHR type challenges to these sorts of issues. So that's a really quick whistle-stop tour through the Coronavirus Act 2020. I should say it received an extraordinarily limited amount of parliamentary oversight, this legislation. So let's wait and see what happens. Mona, can I have the next slide, please? Contact. I wanted to just remind myself, I suppose, of the importance of contact and the importance of dealing with contact appropriately when, for example, a care home or any other body supervising the residence of someone in their care seeks to restrict contact significantly, because it always, sometimes, I should say, not always, sometimes falls as a sort of secondary consideration, and it depends on the judge, the importance they place on it, of course. But just reminding SRNA LA, which is 2018 case, it reminds us that first of all, there's nothing in the DOLS regime that standalone governs a restriction on contact, and second, it's a vital feature of a person's humanity that they would be and they should be entitled to contact with those that they feel is important to them, and any restriction in that contact is a draconian and important measure that must be justified. How, of course, does this all fit with the current climate? The difficulty we have is seen in this is at the bottom of the slide, the reference, the guidance for residential care, supported living and home care. This is a piece of guidance that practitioners will know well, that really says, and it distills contact, face-to-face contact, into very basic principles, that family and friends should be advised not to visit care homes except next of kin in exceptional circumstances, and they list such as an end of life. Visitors should visit the resident in their own room directly upon arrival and leave immediately after the visit, and all the other restrictions and also the promoting of more technical ways of getting in contact with loved ones, so video phoning, telephoning, whatever. But I think that's a slightly different point, because of course what that's saying is let's try and restrict contact. It's not dealing at it with the other way or the other perspective, namely the cessation of contact from P's perspective. And all BP does in a number of different ways is reminds us all of the obligation, even with the guidance in relation to COVID-19, that there is still a prima facie right to Article 8, right to contact with family and loved ones, and any measure that is dealt with within the umbrella of a DOLS application that may restrict contact has to be subject to continued scrutiny, even though the guidance is saying, well, let's step back from direct contact because it's in the interest of everyone. And Hayden, of course, says specifically, which is consistent with a lot of what he's saying about a lot of this, including remote guidance for hearings, including guidance direct to care home managers, that the draconian restrictions on contact sought in BP or suggested in BP can only be justified where all reasonably practicable steps are taken to secure the maintenance of such contact as can be achieved. So it's heavily caveated, despite the guidance, that contact should be achieved by whatever means is possible in the circumstances. So I wonder whether that is teaching a lot of you to suck eggs, because of course you as practitioners are dealing with disgruntled family members or care homes asking for advice. But it's important to recognise, despite the guidance, there is an underlying, more theoretical need to promote contact, which I'm sure everyone has. So I now want to, Mona, if we can, turn to the participation of P. This section of the talk covers a number of different things, really, and it highlights what is fundamentally important to all of the work of the Court of Protection, the Mental Capacity Act, and in fact the whole trajectory of mental capacity law in this country, certainly from the early 2000s, and that is putting P at the centre of everything. And what I found quite interesting about the legal developments since the coronavirus has been the persistent reminders from the judiciary that we must not forget P in all this, because in certain circumstances and in certain cases, P, albeit lacking capacity to make certain decisions, has a very important role still to play in the conduct, the practice, the practicality of court proceedings, because of course it's decisions being made about them, and that is consistent with the whole raft of international obligations the UK has, including but not limited, of course, the rights of the International Convention of Rights of the Disabled. So it's been very important, and actually you see it's important underlined. I've given the reference there, which I'm sure everyone's read. It's quite a long piece of guidance at the remote hearings from Hayden, the Vice President. And P's participation is specifically referenced there. The difficulty is, of course, it recommends practical ways and encourages practitioners to include P in practical ways. But of course, that only fits to a certain number of cases that we all know. And what that can't do is, and I'll talk about this in a minute when I talk about the CCG versus AF case, that what it can't do sometimes is bridge that gap between P having a voice and it simply not being safe for that voice to be heard, or it not being possible for that voice to be heard. So Hayden, the Vice President, in his guidance, suggests that, of course, we have to include P where we can. We have to use platforms, technology, and any other sort of mechanism. But of course, that's all well and good. Practically, how that applies depends, of course, on the level of disability, the level of engagement that P is capable of doing. We see. So I suppose the conclusion is the sentiment is good, but practically it's going to cause very difficult problems in the coming months. And I understand that obviously that Hive, which is the working group that I've referred to and Tom is going to speak about in a bit more detail, are obviously looking at this issue, but I can't see a resolution to it. So, and we also see very similar guidance coming out in the family division from the president of the family division. And also, interestingly, for those of us appearing in court, the Court of Protection Bar Association has produced some advocacy guidelines about remote hearings, which are quite useful. But I want to just raise this note of caution about CCG and AF 2020. I think it was the first case to be held by Skype, and it straddled certainly the introduction and the passing of the Coronavirus Act, and I think it just preceded the lockdown. So it was happening in the middle of all of this, and it was a withdrawal of artificial nutrition and hydration case. These cases are always of the utmost severity and magnitude for all parties. Now, it was a very interesting learning curve that I think everyone should be aware of, whereby you had the lawyers and the judge who actually thought that the hearing was brilliant and it went very well. It allowed access to justice in circumstances that were very difficult. And it would be not churlish for me to say that everyone was quite pleased with themselves for how well it went. There were no technical interruptions. all of this was then shared through the judgment and also through some guidance of the president and the vice president. And what we had was a salutary reminder of the importance of these proceedings and the importance of allowing access to justice to those that the court arena may not be something they're comfortable with, because what we had was a scathing assessment from P, in this case, his daughter, who was fighting for the right for this withdrawal of artificial hydration. It was scathing in the sense that she felt excluded. She felt it didn't feel professional with those of us sat in our open shirts with dogs. I think there were a couple of dogs that came into the hearing. And she said it didn't feel like justice. It felt like a stopgap to ensure a box was ticked rather than a serious and engaged attempt to make decisions about Dad. And that was a very saddening thing to read, actually, because we had felt that the hearing had not only gone well from a very practical, everyday perspective, but also it allowed P's voice through his daughter to be heard. So just a salutary lesson for all of us there, and a cautionary lesson, really, that even in the course of these remote hearings, and if one is then considering steps to involve P, real care must be taken to be subjective about how the hearing and their engagement will appear. We see also family guidance, which is really helpful in REA from the President of the Family Division, which puts a lot of responsibility on advocates. And this is really directed at not only the participation of P, but the continuation of final hearings and contested hearings. It puts a lot of emphasis on the experience of those appearing and the suitability of the case, but it's a good case to have a look at. Mona, can we go to my, my penultimate slide, please? Capacity assessments. These are, I've included these because I think they straddle both disciplines, and our participants straddle both disciplines of welfare and more financy private client stuff. Capacity assessments are important from a private client perspective on the basis you've got to be sure that they have capacity to make wills at the moment, capacity to make lasting power of attorneys. All of these sorts of things are cropping up in practice and I'm being asked about. The basic point, again, is the experts have got to do the best that they can in assessing. And we see in BP, the second case that came in, I think, the end of last week, which was really a footnote to the first BP case. The court was at pains to say, look, you've got to take a proactive and creative approach to assessing capacity in these circumstances. Talk to family members, talk to those caring for P, and do as best you can. And importantly, if there is to be an assessment of capacity where the assessor thinks there are gaps, those gaps should be identified in any assessment and returned to later if possible. So it should be a forensic analysis of capacity, but include any gaps in that capacity assessment that the assessor thinks should be filled, and they should be revisited once and if these restrictions are lifted in the near future. So there's a very practical piece of advice and guidance for those of us for those of us we instruct to assess capacity in whatever circumstances, because I think even if the capacity assessor does not have all the information it usually would, there are steps you can take to avoid that. Mona, I'm looking at the time, so I'm rattling on. Can I have my last slide, please? Three other really practical issues in the COP that have been raised primarily in this Hive newsletter. Property and affairs. There's a pilot going on dealing with applications being lodged electronically. There's a huge difficulty, the copper experience, of course, still being stuck somewhere in the early 2000s in that everything is paper-based. They were overlooked with the wide-scale court reforms on the basis of cost. So there's a small group invited to join the pilot scheme for property and affairs, which started, I think, yesterday. Is that? It's the 5th of May today. Yesterday. Community DOLS, there's a working party on making these applications more effective and quick. and really dealing with some of the problems of the capacity assessments that go with those applications. I won't say more on those community DOLS. Tom is talking about DOLS anyway, but there is more information to be coming out in due course about that. And there's a very practical difficulty with those of us with final hearings in our diary. The First Avenue, I'm afraid, has very limited technology in the Court of Protection for dealing with remote hearings. It's much easier at High Court level, High Court judge level. Excuse me. But we're meeting real problems in getting cases listed that really need to be listed. So hopefully they'll continue to review that. But I think Hive have a direct email address that we can share after this, that any concerns can be raised. So that's been a whistle-stop tour through some issues that have arisen since the lockdown. Just looking at the time, I'm going to go straight to Tom now, and I'll just have a review of some of the questions while Tom's talking, and then we can return to the questions at the end of Tom's talk. But Mona, if you can transfer to Tom now, that would be good. Thanks for listening and watching.
Yeah, so thanks, Ed. I'll be looking at the impact that coronavirus has had and is continuing to have on the application of the deprivation of liberty safeguards. Can we move to the first slide, please, Mona? I'll be considering the practical guidance which has been issued by the government on dealing with the DOLS assessments during the pandemic and the processes of authorisation that can take place during this time. I'll then move on to consider how the emergency will impact on the implementation of the liberty protection safeguards on the new DOLS reform. Can we move to the next slide, please, Mona? Practitioners on the ground have been comparing the impact of coronavirus on DOLS to the impact that the Cheshire West judgment had on the sector in 2014. Now, where that crisis resulted in a Law Commission review, proposals to the government, consultation, a lengthy period of implementation with experts feeding into that process. The front line and the health and social care practitioners, the lawyers, the courts, the judges, we've all had to evolve fairly creatively and fairly rapidly to deal with this crisis facing DOLS. Now, in the letter sent from the Vice President yesterday on behalf of the Hive Group, that highlights particular problems which have been identified in relation to deprivation of liberty cases specifically in the Court of Protection, mainly due to the statutory bar upon the court using its powers under Section 21A to extend DOLS authorisations for more than a year. And the Hive Group have said that they're looking into this particular issue, so this is something to look out for. Can we move on to the next slide, please, Mona? The first point to note is that DOLS has not been directly affected by the Coronavirus Act 2020. Where there have been some suspensions, as Ed has mentioned, to the Care Act duties in England and the social services and wellbeing duties in Wales under the Coronavirus Act 2020 to assess and meet needs, the DOLS have not been amended formally. And similarly, more broadly, the Mental Capacity Act has not been relaxed in any way. It was thought by many practitioners and many bloggers and many academics as the Coronavirus Act was being passed that some of the statutory responsibilities would be relaxed in respect of DOLS. And they've not been. And that's quite telling, because that shows that the government clearly thought that any suspension of the DOLS would result in a breach of Article 5. However, the UK government has produced some emergency guidance to help those dealing with DOLS cases on the ground. It was published on the 9th of April 2020, and so currently is in effect, but it's time limited. So it only applies for the period of the crisis until such time that it's withdrawn by the government. It's important to note the guidance is not based on any statutory easements to the MCA and the DOLS. It's designed to make the system work more efficiently. It's designed to be a practice tool for practitioners, which largely restates the current state of the law. It's also not statutory guidance. It's not formal guidance. but it is something that decision makers should be taking into account. The 5 key principles of the MCA will continue to apply in respect of DOLS, and any decision must be specific to that particular individual. There cannot be blanket decisions during the lockdown period. I think there are some Wales-based practitioners on this webinar. The guidance is issued by DHSC. It's not jointly issued with the Welsh Government, but the guidance is for decisions made in both England and in Wales. Can we move to the next slide, please, Mona? The guidance also sits alongside some other important pieces of guidance already issued. The first is responding to COVID-19, the ethical framework for social care. Anyone familiar with the ethical framework for the pandemic flu will recognise its contents. It sets out principles to follow, which are intended to provide a framework to support decision makers facing challenging decisions in adult social care. The second piece of guidance is produced by the NHS, the COVID-19 hospital discharge requirements. I've put on the slide the relevant part of the requirements for the purposes of DOLS. This effectively says that if the proposed arrangements amount to a deprivation of liberty, DOLS still needs to apply, and any DOLS authorisations should not delay discharge. Now, a lot of commentary from practitioners has emphasised how difficult this guidance will be in practice. The requirements state that patients should be discharged as soon as they are clinically safe. Transfer from the ward to a designated discharge area should be within an hour of the decision being made, and then full discharge from hospital taking place 2 hours after that. So in respect to the DOLS, if you're following procedures correctly, it would be very difficult to comply with that 3-hour deadline as recommended. Can we move to the next slide, please, Mona? So the guidance sets out the meaning of a deprivation of liberty for the purposes of this period in COVID-19. It says, firstly, and most importantly, that any life-saving treatment will not be considered a deprivation of liberty as long as the treatment is materially the same as that given to persons not suffering from a mental disorder. So this is effectively a restatement of the Court of Appeal judgment in Ferreira, which involved a person in an intensive care unit who was subject to certain restrictions in the ICU. But the Court of Appeal in that case in Ferreira held that these were the sorts of restrictions which would be placed on anyone in an ICU, and therefore it was not a deprivation of liberty. But the Department of Health and Social Care seemed to be taking Ferreira one step further. So where Ferreira involved a hospital setting, an ICU setting, DHSC is saying that that same principle applies in a care home. So that's relatively novel. It means for any person receiving life-saving treatment as a result of coronavirus, either in a hospital or in a care home, this will not be considered to be a deprivation of liberty at all. It won't require an authorization. It's also likely that life-saving treatment will also include treatment to prevent deterioration due to COVID-19. It's not just that acute medical treatment which is included. So taking a step back, most cases where there is treatment needed for COVID-19 will not be a DOL and will not require an authorization. Any decision taken will need to be covered on a best interest basis where that person lacks mental capacity. Can we move to the next slide, please, Mona? If there are additional measures imposed, then the Cheshire West test will continue to apply during this period. There's nothing in the Coronavirus Act which alters the application of the Cheshire West test. And incidentally, under LPS, the test also remains unaltered. That is namely that there must be an objective confinement, a lack of valid consent, and that confinement is attributable to the state. As a summary, in respect of the first component, the Supreme Court in Cheshire West held that a person who lacks mental capacity is deprived of their liberty if they're not free to leave and under constant supervision and control. And the Court of Appeal has put a gloss on the not free to leave element, saying that it means not free to leave that accommodation permanently. So thinking about the current situation and DOLS, for many people who were not on a DOL before the lockdown, temporary changes to their care during the lockdown period will not amount to a DOL because they are not free, because that not free to leave element is not permanent. So it will not amount to a DOL at all. Can we move to the next slide, please, Mona? However, if the person has extra measures imposed upon them to facilitate self-isolation, if the acid test is met, you firstly have to consider whether those restrictions can be minimised or brought to an end so that that person will not be deprived of their liberty. That's the first step. The second step is then, if there is a deprivation of liberty, decision makers will need to consider whether P has a DOLS authorisation in place already or an order from the Court of Protection. If the new circumstances of the deprivation of liberty fit within the parameters of the existing authorisation or the court order, then no new authorisation will be required. And it's likely that if there is an existing DOLS authorisation in place, this will normally cover the new arrangements. The supervisory body, the court, doesn't need to become involved. If, however, the arrangements are more restrictive, which may well arise because P will now have to be isolated or their freedoms further limited in a way which engages Article 5, then a review should be carried out. So this is in effect the third stage, and only at this third stage should a review be carried out. And if the existing DOLS authorisation doesn't cover the arrangements, then a DOLS authorisation or a referral to the Court of Protection is likely to be needed. On the ground, it appears that most councils seem to be focusing on renewals, but all new requests do still need to be prioritised. The two procedures for authorisation will continue to operate during this process: standard authorisations and urgent authorisations, which obviously come into effect instantly when the form is completed. They last obviously for a duration of 7 days plus a further 7 days extension. However, a special urgent authorisation form has been produced by DHSC. This is a positive addition to authorising a DOL during the lockdown period, as it's a shortened, slimmed down version of the form. It's only 2 pages in length and grants an urgent authorisation during COVID-19 only. The 7-day extension can be dealt with on the same form, and I've put a link on the slide to the new form. One important point before moving on to the next slide, it's not covered in the guidance, is the importance of ensuring that authorisations are reviewed after the lockdown period ends, with any increased restrictions being removed as soon as possible from a person's care plan. These restrictions, if they are to be Article 5 compliant, must be time limited. There are some English local authorities taking part in this webinar, I think some LHBs in Wales as well. Supervisory bodies during this time should continue to prioritise DOLS referrals during the emergency. And in respect of visits to care homes, the government have advised that during this period, assessors should not visit hospitals and care homes unless it is essential. If you cannot get to see the person, then you can use past assessments in certain circumstances to inform the new assessment. Ed has already dealt with contact between P and the family during this period, which should be now taking place remotely. But as far as DOLS is concerned, most challenges come from a family member or from an IMCA. Therefore, it's concerning that we cannot definitely say what's happening in care homes at the moment. As such, during this period, the need for human rights protection is now greater than ever, and the need for Section 21A challenges to continue is important. Now, of course, applications to the Court of Protection are already made electronically in respect of Section 21As. There doesn't need to be a delay in bringing these applications, even if there is a further internal delay within the Court of Protection itself in listing applications thereafter. It is possible that this guidance will be updated by DHSC as it's continuing to receive feedback on the guidance. So do watch this space. Moving on to the second topic that I'll be talking about, the implementation of the LPS and the impact of coronavirus on the implementation. As you will be aware, the UK government and the Welsh government, alongside dealing with the pandemic, are also implementing the new LPS system. In this pandemic, it's very easy to forget that this important work is going on in the background. This work arises from a House of Lords Select Committee report from 2014, which concluded that the DOLS were not fit for purpose, and in that same month, the Cheshire West decision widened the definition of a DOL. The Law Commission reviewed the DOLS and called for their reform as a matter of pressing urgency, setting out a new scheme for authorisation called the Liberty Protection Safeguards. Could we move on to the next slide, please, Mona? The Mental Capacity Act, the Mental Capacity Amendment Act 2019 received royal assent last year, and the target implementation date is October 2020. Can we move on to the next slide, please, Mona? The LPS will be the new administrative process for authorising a DOL in any setting, not just in care homes or in hospitals. And the 2019 Act does not define a deprivation of liberty, but retains Section 64(5) of the Mental Capacity Act, which provides that references to a DOL have the same meaning as Article 5, so Cheshire West survives. Could we move on to the next slide, please, Mona? The LPS will extend the administrative authorisation process to those aged 16 and over, and it also trims down the administrative process. And I've put the 3 assessments that will take place into the new process on the slide. Moving on to the next slide, before arrangements under the LPS can be authorised, a consultation must take place with a number of individuals in order to ascertain the wishes and feelings of P. And moving on to the next slide, the LPS will include a pre-authorisation review process. The authorisation can last for 12 months and can be reviewed for a second period of up to 12 months and thereafter for 3 years. So that's a very brief overview of the new LPS system, which ought to be coming into effect in October of this year. Moving on to my final slide, there's been a lot of sector concern about what the impact coronavirus is going to have on the implementation of the LPS. Alex Wakefield from DHSC has indicated last week that the UK government is now considering the implementation timetable for LPS in light of the pandemic, and the government has indicated that the sector should not prioritise LPS preparation during this period, and a national statement is awaited. But if you look at those people who are working on the LPS Code of Practice, they are practically the same individuals working on the Hive group. So they can't be working on the LPS Code of Practice if they're all working as part of the Hive group. So in light of the pandemic, it seems that an implementation deadline of October 2020 is now going to be difficult. Thank you very much.
Thanks, Tom. That was great and interesting to see. People are still talking about the implementation of the safeguards in this environment. Just looking at the time, I'm happy to receive any questions from any of our participants. Alternatively, if anyone wants to email either me or Tom, feel free to do so about any of the topics we've covered. Tom is, he's been at the forefront of certainly the Welsh Government's response and assessment of the liberty protection safeguards. So he's got a great deal of knowledge about how these things are being discussed at governmental level, which is very important, because I think whilst we're all focusing on the current crisis, there are huge changes just around the corner. So thanks for that, Tom. I think that's really helpful. But as I said, if anyone's got a question, just chuck one on the open questions. We'll hang around for a minute.